A lot of motions were argued today in the Karen Reed case, and I'm going to be going through each one and giving you my analysis and recap of everything that happened today in court. So we started with Turtle Boy, actually, because the judge who's presiding over Turtle Boy's case was there, and Hank Brennan was arguing to that judge, not Judge Cannoni, that he should be able to obtain the communications and text messages between Karen Reed and Turtle Boy. There definitely were some communications there, it seems like. So he wants to get the full extent of all the communications between Karen Reed and Turtle Boy. And why is that? Well, the reason that he's arguing that he gets to see that information is that there are some allegations of witness intimidation against Turtle Boy. Now, if Karen Reed was directing or somehow involved in that witness intimidation, well, then he should be able to discover that and then be able to use it as an argument for consciousness of guilt. Why else would she not want these witnesses to testify if she is not really guilty? So that is why he wants to see these text messages to see if that she is somehow at all implicated in these witness intimidation charges. So that was his argument. The defense back and the argument back, which is really the strongest argument that I've heard, was the fact that the grand jury, when they were considering all these information in front of them to indict Karen Reed, chose not to indict Karen Reed. And we all know how extremely low the burden is to be able to indict somebody in a grand jury proceeding. And there's no defense attorneys there. It's just a prosecutor and a grand jury. So it's very, very easy. And nevertheless, the grand jury did not indict Karen Reed. Now, Hank Brennan argued that even though they did not indict her, still he should be able to discover her text messages and use it because doesn't go to the same standard of probable cause. But eventually the judge took it under advisement. So we will see what happens with that. Moving on, there was a motion to continue the trial. And we spoke about this in one of our previous videos. And I guessed that Judge Cannoni was not going to continue the trial. And that showed to be right because she does not want to continue this trial at all. She denied that motion. So this trial is going April 1st. Again, anything can happen up until then, but as we sit here today, this trial is absolutely going April 1st. We're not going to wait for any appeals, any opinions to come out. We are going straight forward with this trial. All right. Then there was a buffer zone motion to that Hank Brennan wanted a certain area of the courthouse to be there should be more of a buffer zone, and that was also taken under advisement. Then there was some issues about a witness list that under the new rules, you have to provide contact information for the witnesses, cities, towns, phone numbers, addresses. So that's something that they have to also take care of. And okay, so that was taken care of. They're gonna take care of that. Next, moving on to the lack of bias when it comes to the ARCA witnesses. So this is a motion that the defense wants to be able to show the jury or tell the jury that the ARCA experts were hired by the federal government, by the DOJ, by the U.S. Attorney's Office. Why is that, and why is that relevant? Well, the reason why it's relevant, and this is what the defense's argument really was, is that we already heard from that the jurors were speculating, even though they were told a number of times not to speculate and to only use the evidence that's presented in court. But nevertheless, that's what people do. That's natural. People will speculate. So the jurors, from some of the reports, definitely from the interview with the juror said that the jurors were speculating how ARCA got involved in this case at all. And some of them suggested that it was actually because of the insurance for Karen Reed's vehicle were the ones that hired them. And therefore, obviously, it would be beneficial for the insurance company, for the ARCA experts to come out and say that she didn't hit him. And therefore, the insurance would not have any liability in this case. So either it was her home insurance or car insurance. That's what the jurors seemed to have been speculating about. And then also there was some speculation from the jurors and reports from jurors that there was that they were doing it for their own name to get themselves out there. And that's why they made themselves available to testify in this case. So that was another reason that's a speculation. And if we don't tell the jurors that no, that these witnesses were actually hired by the federal government, then you're allowing them to speculate, and that can be very prejudicial for Karen Reed, and especially if they're speculating in a way that hurts Karen Reed. So that's why they are arguing that they should be able to turn that over. Also, argue that to the jury to let the jury know that they were hired by the federal government. Also, there was the idea that the defense, or definitely some implications or argument that the defense were holding back information from the archives and not providing that information when we know the federal government was the one who was not providing certain information to the ARCA experts. So again, it looks like the defense is withholding information from the ARCA experts, and the jury should know that no, we did not withhold anything. In fact, Yannetti said that he turned over his entire file. He got a subpoena for his entire file. He turned over his entire file, and the U.S. Attorney's Office decided which pieces of information to give to the ARCA experts, and therefore the jury should also not walk away with this idea that the defense is manipulating what pieces of evidence to show the ARCA experts and which ones they are deciding not to show them. That was that part. Now, Brennan's argument really back was that the problem with this is that if you're opening up this whole can of worms, that they were really hired by the federal government, well, then we really have to explore thoroughly if there was any sort of communication between the federal government and the defense, and what extent that communication was. And we really have to do a much more of a deeper dive to determine exactly how completely unbiased these ARCA experts were. After all, Hank Brennan said that this entire federal investigation was opened up by the defense. So there definitely was some sort of communication there between the defense and the federal government. So, what you're basically doing is you're opening up a trial within a trial. You're going to have a trial about the ARCA experts and their involvement and their bias within this trial of Karen Reed, which is obviously not what you're not supposed to do. You're not supposed to have a trial within a trial. So what Brennan was saying is that once we open up that can of worms, it's going to be very difficult to not completely and fully explore the entirety of their involvement with the U.S. Attorney's Office, what that looked like, what involvement from the defense attorneys there was, and so that's the issue there. So what Judge Cannoni decided to do was that she said, what we're going to do is we're going to have a voir dire of the ARCA experts. So number one is that we know that there's some Rule 14 obligations that the defense has to turn over. Some Rule 14 reciprocal discovery that they have to turn over. And the question is whether they're going to be able to comply with the Rule 14 obligations, because they may not have access to a lot of these information that they're required to turn over under Rule 14. So that's question number one. But then the other part is that Judge Cannoni is going to allow a voir dire about these ARCA experts. So we're going to be seeing another voir dire in the middle of trial. Now, first she said we're going to have it next week, but then she decided, you know what? We're going to have it in the middle of trial before they testify, kind of like what they did in the first trial. So that was in terms of the ARCA experts. So we're going to have a voir dire with them, and we'll see a lot more information at that time. Now, there was another motion which we spoke about, which was the motion to be able to state your grounds for objections. And this is something that I have told you about a number of times. It really irked me. It bothered me that the attorneys are not stating the basis for the objections. We don't know what the basis of their objections are. And there was some argument a little bit about whether you're waiving certain issues when you're just stating an objection and not stating the basis of your objection. We spoke about this in previous videos, and we did some research on it. And there was one case where it seemed to be that the court had to guess at what the basis of the objection was, and that's not something that Yannetti wants. So therefore, or the entire defense team wants. So therefore, they want to be able to at least state the grounds for the objections and not just always have to go to sidebar and interrupt the trial. And they don't always want to go to sidebar. So then there may be just some objections which they don't even know what the basis is, and they don't understand the ruling for. So that was the motion to allow them to state very clearly and very succinctly about their basis for objections, but Judge Cannoni denied that motion. So we're going to be going to a lot of sidebars most likely during this next trial. Okay, then there was a motion about the false statements by, I think it was Trooper Proctor, about Yannetti. Some of those statements that he was hanging out by the school, whatever those statements were. So that was allowed. Hank Brennan had no interest in bringing that up, so he's not fighting that. And yeah, those statements, those false statements by Trooper Proctor are not going to be coming in. Now, there was also a brief mention about the motion for reconsideration about Crosby. Now, you remember, Crosby is the Commonwealth's purported expert about dog bites. And here was when Alessi made his argument that he simply lacks the qualifications. He's not a doctor. He's not a forensic odontologist. He's not a veterinarian. And therefore, he should not be allowed to testify about causation of these wounds to John O'Keefe's arms. And Judge Cannoni denied that motion and did not even order a Dalbert Lanigan hearing. So this was his motion for her to reconsider that ruling. And what she did was, with respect to this motion for reconsideration, which, again, most likely she's not going to reconsider it, and I think that this ruling was an error, but what she is going to do is she's going to take this up after Dr. Russell testifies, because after all, we have to see whether the Commonwealth is even going to call Crosby, because the Commonwealth said they're not intending on calling Crosby in their case in chief. They're going to wait to see or hear what Dr. Russell testifies to, and I guess see how the cross-examination goes with that. And then at that point, make a game time decision about whether to call Crosby. So at that time, that is when she's going to take up this motion for reconsideration. Then there was a motion about juror contact, that the Norfolk DA's office and the Massachusetts State Police should have no juror contact. And of course, the judge agreed with that. No one's going to argue that they should be able to have contact with the jury. So only court officers are going to be allowed to have juror contact. There's a motion for a stenographer and to impound jury information. So here, just the question really was, what exactly is Hank Brennan asking for? Is he asking to impound just the sidebars about the juror information? And the stenographer was already granted, that's no problem. But the question is, or is he going to also seek to impound all sidebars, not just about the jurors? And the argument that the defense made for this is that it should not be impounded. This is an open courtroom, and just because this is not something that the jurors can hear doesn't mean that the public should not be able to hear it. And of course, the more that we keep the courts open, the more that we can give confidence to everybody out there that everything's running the way that it should be. So the sidebars should not be impounded. They should be open. Everyone should be able to hear what happened at sidebar, except as it relates to the jurors. If it just relates to the jurors, everybody's agreement, okay, that should not go out to the public. But what about all the other sidebars? So Hank Brennan did not think that it was a great idea, because maybe some jurors are going to hear about the sidebars, and these are things that they're not supposed to hear about. Now, jurors are not supposed to be going on social media at all. And if you trust the jurors in their duty, and they take, they're not supposed to be going onto the internet or reading any reports, so then there's no way they're going to hear about these sidebars either. But Brennan's saying, just out of an abundance of care and caution, maybe we should not have the sidebars open to the public. And Judge Cannoni said, I need some authority. And maybe you've heard that from me before, that you always have to provide authority to the court if you want the court to do something. So Judge Cannoni put the burden on Hank Brennan, saying, look, you want me to take away this portion of open court, well, then you're going to have to provide me with authority that allows me to do that. So that is how that was left off. And Hank Brennan now has to go do his homework and try to find some case law that allows her to impound these sidebars. And actually, he has to provide it to her by tomorrow afternoon. So he's got some deadlines. Next, we had the in-court identification motion that was allowed to identify who Karen Reed is. Yes, she's sitting at the counsel table next to her attorneys. There was some pictures of the victim, of John O'Keefe. Some of those pictures, that's going to be allowed. Then there was the issue of whether to redact the manner of death on the death certificate. Okay, so Hank Brennan's argument here is that the death certificate should not state that the manner of death is undetermined. That should be completely off of scratched from the death certificate. Now, he said that, of course, you're allowed to ask questions about it. I'm not asking that the defense attorneys not be allowed to explore the manner of death, but just in terms of the death certificate, I want the manner of death off of the death certificate. Now, the defense first started off, Elizabeth Little actually argued this motion. First, she said, well, that the defense is not, the Commonwealth is not even calling the medical examiner, Dr. Scortibello, that they're not even going to call her. So that's number one. They're not even calling the medical examiner for us to even ask these type of questions to. They're just going to call this neurologist to talk about that. But then she made an actually very interesting argument. And this was the argument, goes the following. By the way, that was corrected. It was on their witness list. She said that it was not on their witness list, and then the Commonwealth found that she is on their witness list. So Dr. Scortibello is on the witness list, so they still may potentially call her. It doesn't mean that they have to call her. But still, if there's no medical examiner to talk about manner of death, well then, and you scratch it from the death certificate, so then, it's going to be much more difficult. But she did bring up a very interesting argument, and that is that the case law does seem to be pretty clear in Massachusetts that the manner of death should be taken off the death certificate. There's a number of cases which stand for that proposition. So what exactly is she going to argue back? The case law is pretty clear that the manner of death should be off the death certificate. So she made a very interesting argument. And that is that all the cases, and this is always, by the way, a very compelling way to argue. I love doing this. If you can do this, it's great. When you say there is no case that I found that says something, That's very, very compelling argument. Okay, now she said what Elizabeth Little argued is that all of the cases that Hank Brennan mentions in his papers, all that case law that says that you can take away the manner of death from the death certificate, that's only when it says homicide or when it says accident. There's no case that she found which allows you to take off the manner of death when the manner of death is undetermined. And there's a very big difference. The difference is that when it says homicide on the death certificate, well, then that's really telling the jury that this was a homicide. So that's unfairly prejudicial. That's still a question that the jury has to weigh in on, whether this was a homicide, generally speaking, in a regular criminal trial. But when you have undetermined, so then that's not the same as telling the jury what the verdict is. It's just saying that the medical examiner could not determine the manner of death. So that was a very interesting argument that she made. And especially when she says there is no case that she found that says that when the manner of death is undetermined, I think that that's a very compelling argument that you don't find ever where the undetermined part gets redacted from the death certificate. So she took that under advisement as well. Judge Canoni took that under advisement. Okay, then there's some a motion for motor vehicle records, which was allowed. And then there's the criminal records of the jurors. That was allowed. That was under advisement. And then we spoke about Dr. Welcher. I shouldn't say we spoke about, but the defense argued, Robert Alessi argued to exclude Dr. Welcher. Now, Dr. Welcher obviously is very, very important in this case. Dr. Welcher is the Commonwealth's biomechanical engineer who's going to explain to the jury how these injuries to John O'Keefe are consistent. And I guess maybe also the damage of the vehicle. I'm not sure about that. But this could have happened. Backing up the vehicle, hitting John O'Keefe in the arm, and these injuries sustained, that this all could have happened. So this is going to be a very important witness for the Commonwealth. Obviously not for Paul. This is going to be a real biomechanical engineer. So this is Robert Alessi's motion to exclude Dr. Welcher. And he made some very, very compelling arguments. So first of all, I do want to point out that he was talking about what a biomechanical engineer's job is and really what his scope is limited to. And really, he says that really it all goes around a very basic equation, law, basic physics, law of physics. And he said, which just made me laugh, that he said, at the risk of being a little too nerdy. And then he continued with going into the exact equation of Newton's law that they're talking about. So it was just funny when he said those words, I thought. Anyway, so then he said this is all about the force. It's all about force and mass and physics and equations like this. But when you go off of that and you start talking about other things, well, then that's really out of your expertise. It's out of you're not qualified to talk about some other things. That's what you, as a biomechanical engineer, should be limited to, is talking about force, talking about mass, talking about velocity, things like that, physics. So that was one part. Another part that he argued is that if you look through Dr. Welcher and his entire report, again, he doesn't tie his methodology that he's using in this case to any specific study, which has some sort of common acceptance in the relevant community. So, or doesn't meet the Daubert factors. So again, when it comes down to maybe he's qualified, he didn't really argue about his qualifications too much as it relates to certain parts of his opinion. But when it comes to his methodology of how he determined, how he came to his conclusions, he said that you have to, of course, under Daubert, you have to tie it to specific studies and that have common acceptance and satisfy the Daubert factors. And he just simply didn't do that. He also spoke about this experiment that he did. So apparently Dr. Welcher did some sort of experiment where he painted one arm blue and he painted another hand yellow. And that's kind of how he's showing how this accident could have happened. Now, he quoted Rintala. Rintala is one of the important cases that talk about Daubert-Lanigan. It has to do with paint. It has to do with a paint expert who is going to give an expert opinion in that case about how fast paint dries. It's about drying paint and spilling paint and what conditions can paint dry and things like that so that they can determine whether it was poured or spilled or by accident, whatever. So that was what that case spoke about. I didn't do a deep dive into the case right now. But they're talking about paint. It was a paint expert, and this paint expert did a number of experiments. And this is also, here we have an experiment that was done by Dr. Welcher, and which Robert Alessi is arguing that you cannot just allow an expert to talk about an experiment that he did. there's certain qualifications. You have to fit that experiment into certain factors in order for it to be admissible. So that's something that the Rentala case did not allow. They did not allow. The reason why they reversed it is because that was an error to allow this paint expert to perform these experiments on paint and pouring paint and different ways that he tested the paint to see how fast it dries, things like that. So his main argument here was that this experiment should be stricken. He should not be allowed to testify about his experiment that he did with this painting an arm blue and hand yellow and trying to reenact what happened here. He also said that he never performed this experiment before, which is a very important part of Rentala. Although Rentala, there's a lot more to talk about Rentala, and we're going to talk about that in a second. But he said that when you don't perform these experiments as a general practice of yours, and you're just performing this experiment for this trial, you just created this experiment for this trial, well, then the courts are going to look a lot more closely at whether this experiment should have been admissible or not. So his argument was that this experiment was obviously only created for this trial. Now, of course, what everyone was thinking when he was arguing this, and this is exactly what Hank Brennan did argue, is that that's exactly what the ARCA experts did also. They also created this canon, right? And this was also just for this trial, unless they create canons all the time, but it didn't seem like that. So you know that that's going to be argued by Hank Brennan. That's what he did argue. Okay, but we'll get to that in a second. Now, something interesting also that we noticed from Robert Alessi is that when he was talking about Rentala, something that he did, which has a soft spot in my heart, is that he quoted a footnote. And you guys all know how much I love footnotes, right? So a lot of times you get some really good, juicy stuff from the footnotes. So he was quoting actually footnotes. So I appreciated that when he was doing that. So that was with that. He also spoke about the fact that a lot of Dr. Welch's report is talking about some of the testimony that was given by Jennifer McCabe and by Julie Nagel and some of the other people involved in this trial. And he said that's completely inappropriate. It's way out of the bounds of a biomechanical engineer to start considering what contested facts are based on certain people's testimony, especially if it's contested. So he can't do that. That was a big part of his argument also. And then he was talking about how part of his conclusions are from the pattern in John O'Keefe's injuries are consistent with the pattern of a broken taillight. That's part of what his testimony is going to be. So then it sounds like, hey, this sounds a lot like pattern recognition analysis. Now, is there any sort of expertise in biomechanical engineer that you're allowed to testify or that gives you the right to testify about pattern recognition analysis? Or is you're limited to force, mass, velocity, those type of equations, physics equations? Now, when it comes to pattern recognition analysis, so he said that also should be out of bounds for him. Also, the fact that there's frozen ground, that he hit his head on the back of the ground, and the frozen ground is what caused this blunt force trauma to the back of his head, of John O'Keefe's head. How can he talk about that? Remember, the frozen ground, I think we're still waiting on the order about the meteorologist, whether the meteorologist is going to be able to testify that, but definitely out of the expertise of a biomechanical engineer to know how ground freezes and how hard ground is when it freezes, or the freeze and thaw cycles. So that's that. And he also made a point of saying that something that he talks about in his report, Dr. Welcher, is the totality of the evidence. After looking at the totality of the evidence, you can't do that. As a biomechanical engineer, you're not supposed to weigh all the evidence and say, well, in the totality of the evidence, and he also spoke about what Karen Reed said. And what the other reports are about who went in the house and who didn't go in the house, that John O'Keefe didn't go in the house. So, so that was part of that was a lot of his argument. And then really what happened was Brennan got up there and he basically acknowledged that some of these areas are out of his expertise and he's not intending to offer him to testify about some of that. Now, he did argue that once a witness does testify in a case, the expert is allowed to consider that testimony in coming to his conclusions or talking about that testimony. So he doesn't plan on calling Dr. Crosby in one of his first witnesses. First, he's going to call all these other witnesses like Jennifer McCabe and Julie Nagel and all these other witnesses that were in the house. He's going to, so he's going to set the stage to have the foundation to be able to then ask the expert based on what you heard from Jennifer McCabe or these type of things. So then, he'll be able to give it an expert opinion about that. So that was part of Brennan's argument back. And he said that this is really just, we provided them with everything, even though we're not really intending to use everything. So what he was also arguing is that, a lot of the arguments that Alessi made should also apply to the ARCA experts. If you're talking about experiments, you're talking about this canon, well, then that's also an experiment. So are you really arguing against our witnesses, or are you arguing against your own witnesses, the ARCA experts? So this is what I saw from the Rentala case, and I'm not going to go do a whole analysis of the Rentala case. I probably talked about it in previous videos, but it's going to just take too much time. It's going to take too long. But what my understanding from Rentala is that there was a lot of problems in Rentala. There was a lot of problems with his experiment and his expertise. You think about it in the first place, a paint expert. Ever heard of a paint expert before? Okay, so that's number one. And then you're getting this paint expert to do all these experiments, and they go through all the experiments and they go through all the problems with the experiment. They weren't necessarily saying that automatically an experiment is not allowed in trial. Experiments are allowed in trial, even if they're done for this specific case. This does happen. There's an issue. They create an experiment to be able to give their expertise and test it and whatever it is. So it does happen plenty of times in cases where experiments that experts use are admissible in court. So Robert Alessi did make a good argument about it, but at the end of the day, most likely these experiments are going to be admissible, because as long as the experiments are based on physics, they're based on force, and based on their testing was done properly and appropriately for their expertise, then it's going to be admitted. So most likely the Canon experiment is going to come in, and this experiment that Dr. Welcher made, that's also going to come in. He also spoke about that. He also considered the text stream data. We know that this was a big talking point, that the ARCA experts didn't consider the text stream data, or weren't given the text stream data. And here you have Welcher, who was given the text stream data. So that's also going to be part of his expert opinion. So that is essentially what Brennan's argument back was, and he's going to really kind of change the PowerPoint, take certain things out. So he's just going to he is acknowledging some of the problems with this with the report and what exactly the scope of his testimony is going to be. Eventually, he's going to be allowed to testify, and he's going to be allowed to testify that these injuries to John O'Keefe are consistent with being hit by a car. So that's going to be a very interesting part. And the cross-examination, of course, is going to be very interesting, because most likely what's happening now is that Alan Jackson, or the defense attorneys, are giving over the report to the ARCA experts, and they're going to be asking the ARCA experts about this report. So and they're probably going to be asking them to see, does this make any sense to you? And if it doesn't, we're going to talk about it when you're on the stand. Okay. So then they moved on to chalks, whether chalks are going to be allowed. Chalks are going to be allowed. There's a Celebrate demonstration that was argued about whether certain parts of the Celebrate is going to be in the demonstration from Whiffen and Jessica Hyde, if they're going to be admitted or not. That's also taken under advisement, I believe. And then we have the very interesting issue of the victim's state of mind. Now, this is a very interesting issue. The reason is that the question is, what was John O'Keefe's state of mind? Was he going to break up with Karen Reed? And if he did, is that important? Is that admissible evidence? And what's going to happen is that you see those, we know from those text messages at the first trial, which are most likely going to be admitted again in the second trial, which show that there was some sort of tension the day before. They were texting about some sort of argument that they got into, apparently, and then later that night they went out to drink and everything was fine. But you definitely see some of those text messages, and if they are text messages from John O'Keefe himself to Karen Reed, they're coming in. Okay, those are coming in, no question. The question really more is about the niece's testimony, and the niece's testimony of maybe what John O'Keefe told the niece. Now, the niece's observation of the relationship, that can be arguably admitted to show the state of the relationship. Because again, if the whole point of this is to show that if there was some reason that Karen Reed felt that John O'Keefe is going to dump her and that she's mad at him for that, well, maybe that's a motive. So that would be allowed in, even though there may be some hearsay problems, but still, if it's to show state of mind of the victim and also the state of mind of Karen Reed at the time, so then arguably this evidence comes in. So really, it goes more to the niece's testimony. Again, it also may go to some of the text messages that John O'Keefe sent, maybe not to Karen Reed. So here's the issue. This is what Jackson argued, and it's a very compelling argument. Number one, in order to get this in order to get these statements in, victim statements or statements from John O'Keefe saying how maybe he feels that the relationship is ending and he's going to dump her or things like that, or what the niece is saying about the relationship, is that number one is that there has to be evidence that these communications were communicated to Karen Reed. These text messages Karen Reed knew about. These communications between the niece and John O'Keefe, let's say, Karen Reed found out about. There has to be evidence like that, because the whole point is that it has to tie back into a motive why Karen Reed would then murder John O'Keefe. She has to have known about his intentions of, let's say, dumping her. She has to know about that. And then number two about the second factor is that these, aside from the fact that the communications have to be communicated to Karen Reed, or she has to find out about them, they also have to be the type of communications that somebody would act in this type of way. So if it's just, I don't know, I'm thinking about our relationship. Well, is that a type of communication that would throw someone into a rage and back their car into someone? But if there's a communication, for example, I hate this girl, I can't stand her, and I can't wait to dump her, which I'm going to do tonight. Well, then, okay, that's more of a reason that would throw someone into a rage. So number one is that did Karen Reed, there's got to be evidence that Karen Reed found out about this, all these communications. And number two, are they the type that would throw somebody into a rage like that are reasonably connected to as a possible motive in this case? And also remember that on the day of the incident, everybody agrees that night at CF McCarthy's and the Waterfall, everybody agrees that they were in great spirits and they were lovey-dovey, as one of the witnesses spoke about. And remember, she had her own money. She had her own house. She had a good job. She wasn't married to John O'Keefe. She wasn't completely tethered to him in a way that she was completely dependent on him, that if he would decide to break off their relationship, she would be stuck. So there was a lot of independence. There's a lot of testimony the other way. Now, there was some drama here where Brennan got up and said, well, that's not necessarily true, because she actually knew about the house. I forgot the person's name, Ashley maybe, who previously had a relationship with John O'Keefe, and there was some mention about her house, and there was some mention about that Karen Reed said that she was pissed that night, and that's what she told Gretchen Voss. So there was some sort of drama here. There's always drama in this case, by the way, in case anybody thought that Alan Jackson's calming words about let's calm the drama down had any effect. Didn't. Definitely not in today's hearing. So there was definitely some drama there and going back and forth about what Karen Reed actually said before this or after this. What did she know before John O'Keefe was found dead? So there was some of that back and forth, and so some of that drama. So we had the Celebrate demonstration, which you spoke about, and then we had some motion in limine about the character evidence, the bad acts of the witnesses. So in terms of that, the judge said, well, okay, the defense said we're not going to bring it up, but if it does happen to come up, we don't want to preclude ourselves from bringing it up if it's necessary to bring in. Generally speaking, character evidence is not admissible. Bad acts are not admissible unless to prove motive, opportunity. There are certain times when it's allowed in. So they just said if we feel it's necessary that we have to bring it in, we're going to bring it up with the court beforehand. All right. So then we had the victim witness advocate and Morrissey that the Commonwealth wants them to first show why it's necessary to call them. They are on the witness list, and the defense said they only intend on ever calling them for impeachment purposes if it's necessary, and they also will be excluded from the sequestration order, so they will be allowed in the courtroom if they so choose. All right. Then we got into the internal affairs investigation of Proctor. We spoke about this in yesterday's video about whether the findings of the internal affairs investigation of Proctor is going to be admissible or not. Now, I showed you the case law about that. I showed you the arguments why the findings would be admissible. Of course, Hank Brennan is going to take the opposite approach, and he's saying that no, he doesn't believe that the findings are admissible. He doesn't feel that the conclusions are admissible, and they couldn't really argue fully this motion, because when he filed this motion, that was before the findings for Trooper Proctor came out. So he was just arguing really just on the internal affairs investigation alone without any findings. So now that there's findings, so now Judge Cannone is saying, are you ready to argue this motion, or do you want to go back and do some more research about it? And he said, yeah, although he did make the record that he believes that the findings and the conclusions are objectionable and they should not be able to come in. Again, you can go check out my video I did yesterday about what I believe the case law shows about how there's definitely an argument that the conclusions will come or should come in. All right. Then there was the argument about the third party culprit. Now remember, this is the argument that the defense is going to make that there's a third-party culprit. And here's where people get a little confused about what exactly does it mean a third-party culprit, and does the burden shift at all? So let's just make one thing clear. The burden doesn't shift. The prosecutor still has to prove their case beyond a reasonable doubt. The question only is whether the defense is able to provide evidence and argument to the jury that there may have been a third-party culprit here. And to this, Hank Brennan really focuses his argument on the fact that they cannot identify one individual person. Although I showed in one of my previous videos, maybe he's watching, I showed in one of my previous videos that it's not necessarily true that you have to identify one person. You could identify a number of people. It's possible that one of these three people that were in the room with the person killed him, and it wasn't me, right? So that is a viable third-party culprit defense. Now, Hank Brennan first argued that they can't identify anybody, and then he kind of shifted his argument and saying, even though I understand, because he watched Brother Counsel most likely, but even though I understand that you don't have to identify one specific person for a third-party culprit, but even if you're going to say it's one of three people, there has to be strong evidence. There's got to be relevant evidence, and it has to be substantial, and it can't just be speculation. It can't just be just throwing everything at the wall and hoping something sticks. So there's got to be some concrete evidence connecting people in time and place to and motive to actually wanting to kill John O'Keefe. So that was his argument in terms of that. So David Yannetti got up and said, well, the three people that we are naming, if you need names, are Brian Albert, Colin Albert, and Brian Higgins. And then they had a sidebar about exactly, I guess, the extent of what evidence they have to show that they are connected to this case. Now we know the butt dials, we know the fighting in the play fighting in the waterfall. It was, I think, at that time, or maybe it was C.F. McCarthy's one of the bars where there's some play fighting, and we also know about Brian Higgins' relationship with Karen Reed, some sort of flirty relationship, and we know Brian Higgins on the phone at 1:30 in the morning. So there was some of that, Colin Albert, maybe the fighting. So that's in terms of what they feel that they can connect certain people with motive, opportunity to be a third-party culprit in this case. So that seemed to have been argued at sidebar. We didn't get to hear about that, and we're going to see what Judge Cannoni does with that. I think she's going to stick to the same rule that she did last trial, that is that you're not allowed to mention in an opening statement. Now, we do remember that an opening statement last trial, David Yannetti opened up with this Karen Reed was framed, which certainly seems to suggest that there's a third-party culprit there. So was that a violation of her order or not? Maybe at this trial, she will not specifically allow David Yannetti to open up that way. And by the way, we got a little bit of a glimpse into how the trial is going to be conducted, because David Yannetti said he does not plan on doing the opening statement. So who is going to do the opening statement? I think it's only going to come down to one of two people, Robert Alessi or Alan Jackson. I don't think Elizabeth Little is going to do it. So I think it's just going to be a question of Robert Alessi or Alan Jackson. So you can start taking odds on who's going to be doing the opening statement. But David Yannetti said he's not going to be doing it this time around. So, all right. Then we spoke about, there was the issue about Garrett Wing. I think I got his name right. Garrett Wing is an expert to be able to rebut Crosby. So remember, you got Dr. Russell, and then the Commonwealth is going to potentially call Dr. Crosby to rebut Dr. Russell. And then we're going to have Garrett Ring potentially to rebut Dr. Crosby. So that's going to be fun. So there's been no reciprocal discovery turned over. There's just been a CV of Garrett Wing, and Judge Cannoni just said, okay, turn over everything as soon as you can to Hank Brennan about this expert Garrett Wing, and we'll deal with it later. Then we had Michael Easter. Now, Michael Easter is this FBI investigator for many, many years, an FBI agent for many years, and he seems to be very experienced in investigations and police investigations and whether investigations are adequate or not. So here is where Alan Jackson wants to introduce, or the defense wants to introduce Michael Easter. Seems like he has a lot of connections to LA, so maybe that's how Alan Jackson knows him. So he basically wants him to testify about how botched this investigation was and how certain leads weren't followed up, and collection of evidence, securing a scene. He wants him to talk about all these things that was done wrong in this police investigation. So the argument that Hank Brennan made back is that this is not really in the province of an expert. You have expert witnesses for specific reasons to help the jury understand certain expertise that's beyond a layperson's knowledge. But when you have a person who's just going to argue essentially that the other side didn't do a good job, well, that's the defense attorney's job. So That's what you're supposed to do in cross-examination. You're supposed to show how this investigation was botched and how they didn't follow up on leads. You don't need an expert to come in and say they didn't follow up on leads. That's something that you can do as a defense attorney. So this was Hank Brennan's argument that you should not be able to do that. And Alan Jackson's response was that, first of all, we have some case law, and he didn't say Massachusetts case law, but he said that we have some other case law in other jurisdictions which do allow these type of police experts to testify about investigations. So Judge Cannoni said she needs a case site. Okay, again, what this is called a Bowdoin defense, right? When you're arguing that the police investigation was inadequate. So then this gets into the Bowdoin defense. That's what they call Bowdoin defense. So she said, you need to bring me a case, or I want you to bring me a case. Obviously, I'll look at other cases in other jurisdictions, but she really wants a Massachusetts case, which says that you are allowed to bring in an expert in police investigation to testify about the inadequacy of the police investigations that's the subject of this case. So that's what she asked Alan Jackson to do, get back to the research and figure out, where you can find these cases. Now, Jackson said that he did not find really any Massachusetts cases that say that you can do this, which may be the end of that argument. He may, even though maybe has some cases from LA or other cases that do allow this, but they may be persuasive on Judge Cannoni, but she's most likely going to be looking for a Massachusetts state case. So I did a little bit of research, and I know the video is getting a bit long, but I figured it's good to show you this research. I did a little bit of research in Massachusetts, and I found a case that's pretty similar. I think you can make an argument that this is very, very similar to having an expert testify about the inadequacy of police investigations. And this is called the Commonwealth versus, let's just go up, Commonwealth versus Silva Santiago. All right, so let's go down. What happened here, look at this. What happened in this case, let me just pull this up. All right, the defendant did not testify. It's going through the trial. What happened? The defendant did not testify. His trial counsel called two witnesses, Samuel Perez, a patron at the bar on the evening of the shooting, and Amy Douglas, an assistant professor of psychology at Bates College in Maine and an expert in the field of eyewitness identification. Interesting. So what's she going to testify about? Professor Douglas testified that 3 procedures recommended by the United States Department of Justice in its publication Eyewitness Evidence, a guide for law enforcement, were not followed by police in this case. It sounds like she's saying that certain guides were not followed in this case. Procedures, 3 procedures which are recommended to be followed by the police were not followed in this specific case. Definitely sounds like she's talking about the inadequacy of this, call it investigation, right? First, the witnesses were not told before viewing the photographic arrays that the culprit may or may not be present in the array. So this is talking about a lineup, right? These arrays. So the witnesses were not told that the culprit, meaning the person they think may have committed this crime, that person may or may not be present in this lineup. Without such an instruction, she testified a witness tends to assume that the culprit is present and proceeds to make a choice from the array. Second, so that's the first problem in this specific case. Second, the witnesses should have been asked how confident they were in their identifications immediately after making them. Why? Because some research shows that a witness's confidence in the accuracy of his identification grows once he learns that the police believe he made the correct identification. Third, the identification procedure should be fully documented, preferably by a videotape or audio tape recording. Professor Douglas also identified 2 other recommended procedures that were not employed in this case. First, she testified that many experts recommend that the photographs of potential suspects be displayed sequentially, with the witness determining whether a single photograph is familiar before turning to the next photograph, rather than simultaneously with the photographs of all the suspects displayed together on one page. She noted that the simultaneous method is a very effective strategy if the culprit is in the array, but the strategy is problematic if the culprit is not present in the array because it may lead to a false identification if the witness attempts to ascertain which photograph is the closest to the culprit. Second, she testified that most experts recommend a double-blind procedure in which the person showing the photographs to the witness does not know the identity of the suspect. She explained that a double-blind procedure eliminates the risk that the person showing the photographs will influence the witness identification intentionally or unintentionally. So if you're the police officer showing it, you should not know who the culprit is. Okay. Finally, and she goes on with another part. But point is that I think you see from here that definitely, I think you can make an argument. I don't think it's directly right on point to getting an expert detective to talk specifically, or an FBI agent to talk specifically about the investigation. But you're seeing from here that there was an expert talking about the police procedure when it comes to this array and choosing this culprit. And you see that she's identifying issues with that kind of detective, procedures, or the police procedures, or how they conducted this. So I think you can make an argument. Again, it's not the strongest case. It's not like the strongest argument in the world. I can definitely see how you can start, making, some distinguishing between this case and the case in Karen Reed, and why, a police investigator is different than a psychologist, and they're using different reasons. Although she did quote to some of the documents that talk about police investigations, so it could be all based on psychology, but really it's all still. So I mean, I think that this can be definitely an argument to be made, at least to complete the record. If you got some other cases from other jurisdictions, and this can also be close enough to those. So I think it's an argument to be made. So that's just from the little bit of research that I've done specifically in that case. But other than that, Alan Jackson said that he did not find any other cases that really allow someone like an FBI agent or an expert detective to talk about the inadequacy of a police investigation, which really goes to the Bowdoin defense. So that's really essentially what happened today. So we tried to get it done under 45 minutes for the entire day today, when there's a ton of motions that were argued. The next hearing is Tuesday at 11 a.m. I really hope to be able to live stream that with you and give you my real-time analysis on that. So keep your eyes and ears peeled for that. So that's going to be it for now. We're going to be keeping to watch all the more motions that are filed, perhaps, or anything else going on in the Karen Reed case, and giving you my analysis and breakdown and recap of it. So that's going to be it for now. If you haven't yet, please subscribe, like, and we will see you next time.